Wagwan. Good morning, good night. Welcome back, and if you're listening for the first time, welcome to episode 21 of The Real Situation, where we give you a taste of Jamaican politics. We're still in joint select committee mode, where the bill being proposed to reform the constitution is being reviewed. There's been 8 meetings so far. January 15, that was the first one, where the opposition leader read a statement confirming that there'd be no further participation on their part until 4 questions were answered by the Prime Minister. There was the meeting on January 22nd, which was a presentation on the bill, which featured like an overview of the main clauses that were going to be reviewed by the committee, which is the Jamaicanization of the Constitution, the office of the President, the expansion of the Senate, modification of the alteration provision, that is Section 49, an enhancement to the citizenship provision, the qualification and disqualification of membership in Parliament, and the incorporation of the Electoral Commission of Jamaica. The next meeting was January 29. That was a presentation on the parliamentary cabinet system. February 6th, that meeting was a presentation on citizenship. February 19, that was a presentation by the Ministry of National Security that addressed clauses 7 through 10 and the subject of citizenship and the Commonwealth. And more recently, the last 3 meetings that were held were February 26 and March 12. At both those meetings, the topic was the office of the President. And then there was a meeting on March 19, which the topic was the Parliament and the expansion of the Senate. So before we talk about the meetings on February 26 and March 12, we're not going to get to March 19 today. I wanted to briefly touch on the Ministry's island-wide road to Republic engagements, excuse me, and part of their, which is part of their ongoing effort to inform and educate Jamaicans on the, the legal, historical, and governance aspects of the proposed reform. On their Instagram page, they have some tour dates. February 11, they did a school session in Clarendon. February 21, they did a school session in St. Mary. February 24, they went town hopping between Halfway Tree and Mandela Park. February 26, they did a school session in St. Catherine. And then February 28, they did some more town hopping between Portmore and Portmore Mall. There's also a date on their Instagram page that they were in attendance at St. Catherine High School, and that was approximately on March 17th, somewhere around there. So what I do want to say is I don't know what town hopping is exactly, but I'm going to look a little bit more into it. What they mean when they say they went town hopping, if it's particular places that were targeted, or if it's just moving around town generally, right? Also, the Instagram post didn't identify any other information, who the CRC representative or representatives in attendance were. I didn't see any of the meetings being available to view online. If this is incorrect, please make me know. If you have some information, link me. But I'll keep researching, because usually the meetings are available online somewhere, right? So, the review of the Joint Select Committee meeting on February 26th, okay? It was basically the start of a review of Clause 11, and that involves the office of the President, which was going to be the subject of this meeting. There was a reference made to submissions by the public, points that would be considered but not necessarily require an oral presentation. Members were going to make a declaration after looking at the submissions, and it was confirmed that there were some submissions that were made regarding issues that have actually been slated for the next phase of reform, but that wasn't actually specified what those issues were. There was also a reference made to excuse me one second. Okay, so there was also reference made to the withdrawal of the opposition, pending a response from the Prime Minister, primarily over the final Court of Appeal, right? Marlene Malahoo-Ford confirmed that the government will be taking a thorough look at the three options that they feel are available. Those three options are Jamaica's own final Court of Appeal, and obviously there's a cost issue to take into account there, as well as the availability of judges to sit in it. There's the Privy Council, which is the second option, and there are issues with that. You need a visa to go to Britain. There's obviously the cost that is involved, and also the susceptibility of just being booted out by the British anyway via an act of Parliament, and especially once the head of state is removed. And then the other option is the Caribbean Court of Justice. Jamaica's paid millions into this court and is already a member of the originating jurisdiction, which interprets the Caribbean Treaty of Chaguaramas. The CPC started reading through the provisions of Clause 11. And what it basically does is it amends Chapter 4 of the Constitution, replacing the Governor-General with the President. I can't remember what the CPC stands for, but she's Parliamentary Council anyway. While Clause 12, which refers to the President of the Senate, Clause 13, which refers to the Governor-General, and 14, which references the Crown/Monarch, are also relevant, it was confirmed that only Clause 11 was going to be the focus that day, to allow the members to give consideration to the submissions that had been made. So the title of this part of the Constitution would effectively be substituted, right? It turns the office of the Governor-General into the office of the President. They went on to talk about the qualification for becoming the President. You must be a citizen of Jamaica by birth or descent, and by descent meaning either your parent or grandparent is born in Jamaica. You must be ordinarily resident for 10 to 15 years immediately preceding the nomination date, and not disqualified to be elected to the House or the Senate. So Senator Golding Campbell, she did point out that the President would have significant and critical responsibilities regarding, the appointment of statutory bodies. It's not only ceremonial, but there's a huge role. That person would play a huge role in how the public bodies are constructed, right? The President would make those appointments. So given consideration to that statement, obviously the appointment process is still very problematic, right? March 6, 2025, PJ wanted to, get the record straight, lest we forget, during a reasoning that he had, where he said that he would never agree to the head of state being chosen, I'm quoting, "I would never agree to the head of state being chosen in a manner which makes that person beholden to a simple majority vote." Basically summarising some questions that Senator Golding Campbell had. She was basically saying that, asking why the process for an interim an interim president, where the president is sick, and also the an interim president where the president has suddenly resigned, right? So that's two different types of vacancies. One is going to be a temporary vacancy, and the other one is going to be vacant until filled, right? And she was also bringing attention to the fact that that appointment process is real long. It's like it can take up to 3 months. Basically what she was saying is that as per the interim process, the use of a custos is quicker, right, than identifying somebody outside of that group. Because the office is going to stay empty, especially where, the scenario where the president has just resigned. It's going to stay empty until somebody fills it. So it would be quicker to put a custos in there, or somebody from the President's Council. So we are going to now we're going to skip. There was a lot of discussion around that point. So now we're going to skip to March 12, which is a continuation of the review of Clause 11. So remembering before, right, we said that in order to be the president, you needed to be ordinarily resident for 10 to 15 years immediately before you're nominated, right? So Senator Sinclair brought up a question on that issue, and he was basically, saying why the term ordinarily resident as opposed to just being resident, and why not just 10 years, being resident in Jamaica 10 years immediately before the date of nomination. So Marlene Malahoo Fort she responded and basically said that, it was to take into account those who hadn't exclusively lived in Jamaica or had been abroad, but had sufficient awareness of issues that were going on in Jamaica and had, a lived experience. And I can kind of see, what she's getting at with that. Maybe you're back and forward, between Jamaica and a next country, but you've spent sufficient time in Jamaica and have sufficient ties to Jamaica, to accommodate that lived experience that they want someone to have. And by sufficient times, I mean, you have a yard, you have a business, maybe you have kids in school or something, but you have sufficient ties and, you have, a solid understanding of the experience of what's going on in Jamaica, right? She goes on to say that this is also taken into account with temporary departure or a departure from the island, which is not very long, and that wouldn't be a disqualifying factor. But it's not the intention for the person to be in Jamaica 6 months and elsewhere for 6 months. I mean, what are your thoughts on that? I mean, to me, you would think that once you're appointed, at that point you would be permanently resident in Jamaica, right? And, you could think that it might encourage some existing issues over concerns that citizens have over MPs who get elected and then them gone a firing. So, I don't know. Let me know what you think about that temporary departure. I mean, it would be interesting to know what that definition is. Senator Sinclair was saying, you could just be resident for 10 years before. That temporary resident thing, temporary departure thing, I mean, the president is probably entitled to time, vacation, sick, blah, blah. So what other temporary departure would be necessary so as you need to put it in the bill? Just wondering. Maybe if you need to be away from the island, then, for any period of time, your vacation, sickness, personal, whatever would be, that would be utilised, right? They discussed the procedure for the removal of a president and the ramifications of a decision by Parliament not to remove a president after the proposed quasi-judicial 3-member investigatory panel has submitted a report saying the president is guilty of some form of misbehaviour in office, or an inability to perform the functions, or has conflicted allegiance, or has just run afoul of the law. Marlene Malahoo Fort was basically saying, look, if the legal thresholds have been met following an investigation, Parliament would be expected to, come to the right decision, to the right thing. The panel would be brought to life by a 2/3 majority motion, which would be initiated by the leader of government business. And she was saying, look, this is really an impeachment process, right? But partisanship does have to be guarded against. And, the question was asked, does something more need to be provided? And who would have that power if the vote doesn't meet the threshold, but the committees, they've established grounds for the president to be removed? Senator Golden Campbell was asking, what's the mechanism for that panel to be named? And the grounds for removal are constitutional breaches, so shouldn't that be addressed by a constitutional court? Marlene Malahoo Fort basically said that the leader of the government business would be assigned the responsibility of naming the panel, which is usually done in consultation with the opposition. But Ms. Senator Golden Campbell also said, well, should the leader of the government business be the only one to initiate the motion? I mean, any member really should be able to table the motion. But Ms. Malahoo Fort did say, listen, ultimately the confirmation and removal is undertaken by the Parliament. And then she went on to say that on the question of the Constitutional Court, that's one of the difficulties of providing for impeachment in a parliamentary system. I'm going to ask you to stick a pin on that statement right there, right? I'm going to finish up the meeting summary, and then we're going to come back to the difficulty of impeachment. So basically, Senator Golden was saying that, look, Parliament does not interpret the Constitution, and, could a president who's been removed by Parliament seek recourse in the courts based on an unconstitutional removal? So, and also she went on to say, look, what about the grounds that are included? And they basically were saying that you can have a scenario where, let's just say, a president is accused of sexual assault. It doesn't have to wait for, this panel to be investigating actions that may have been warranted to remove him from office, regardless of whether he's convicted of sexual assault, right? But in any event, they were saying that, there should be a framework set up so that it's workable, and, a determination of impropriety doesn't necessarily rest on that criminal conviction. There's a lot of misconduct which falls short of the criminal standard, which could prevent someone from holding office. So in conclusion, Marlene Malahoo Ford said, look, here are some questions for consideration as continuation of review of the bill. Right? There were 1, 2, 3, 4, 5, 6, 7 questions that they are going to, that are up for consideration. The first one is, who should be empowered to initiate the removal of the president? Should it be limited to the leader of the government business, or should it be open to any member of parliament? The next question is whether the quasi-judicial panel should be named after consultation with the government and opposition. Next question, whether the size of the panel should be expanded given the provision for it to continue even if there is a defect in the number. Whether the vote to remove should be by absolute majority, similarly to the votes to confirm, or whether the votes to confirm should be by 2/3 majority. Whether the interim report required to be submitted on an application for extension of time should be limited to advising of progress made so far and reasons justifying the request for further time. What should the power of Parliament be where there is a recommendation that a ground specified has been made out? A sub-issue is what would happen to a president where a recommendation is made that a ground for removal has been made and Parliament votes otherwise. And is the parliamentary vote challengeable? Ms. Malahoo Ford did say, though, that the intention is for Parliament to be final, and Senator Golden Campbell reminded her of that constitutional question. And then the final question is the residency criteria, ordinarily resident versus permanent residents, and the temporary absence from the island not meaning that you are not permanently resident. So, I'd asked you to stick a pin, right? So we're going to go back to that statement on the difficulty of impeachment. So Ms. Malahoo Ford was talking about a scenario where she feels kind of, MPs are hard done by because they're held accountable for matters that are not always under their control, like road repair. And she read a summary from the Constitutional Reform Committee's report as to why impeachment should not be included in the bill. And we've been here before, right? But yeah. So it's section 6.3 of the report, and it is as follows: impeachment process. During its engagements, the CRC took into consideration the repeated concerns expressed by the public about the lack of accountability among parliamentarians. The CRC discussed at length over multiple meetings the related issues, in particular the CRC acknowledged calls for the inclusion of a process of impeachment and examined the history and experiences of impeachment in other jurisdictions. The CRC further considered whether and how impeachment would work in the Jamaican context. The CRC recommends that there should be no inclusion of an impeachment process in the reformed constitution for the following reasons. 1. It is dealing with what is essentially a legal matter through a political process, as most impeachable offences are criminal in nature and properly triable in the courts. Number 2, it can be easily manipulated for partisan political purposes. It's difficult to ensure an impartial hearing by members of a parliament that is divided along partisan political lines. 3, the parliament would have to be provided with its own investigative resources. 4, where the matter being investigated involves the allegation of a crime, then the normal criminal proceedings would be invoked, which creates the risk of competing and conflicting jurisdictions and outcomes. And 5, in cases where impeachable offences are not criminal offences, the definitions are generally vague, and therefore the impeachment process is inconsistent with the principles of natural justice. So first off, the proposed removal of the president is effectively impeachment, right? So if you impeach a president, why wouldn't you impeach a senator or a member of parliament? So kind of in my mind, what Marlene Malahoo thought was describing in her road repair scenario, that's not the accountability that's being addressed in the impeachment bill. That impeachment provision isn't wanted because people want to frustrate their MPs over the breakdown in the functioning of government. You can't blame a public official, trying to serve in a broken system. Maybe what they should be doing, or maybe what we should be expecting them to do, is to push for its repair, right? So it can function properly, efficiently, and effectively. No, this impeachment bill comes from a different approach. So what is the impeachment bill trying to do? The impeachment bill that I'm referencing is the bill that was drafted in 2011. But it wasn't debated in Parliament, and it was originally drafted by Bruce Golding. It wasn't debated in Parliament, and a list of impeachable offences was expanded to give it wider coverage of conduct that is unbecoming of a holder of a high public office. So it was revised in 2021 by Mark Golding and called the Constitution Amendment Impeachment Act of 2021. So the bill is basically saying that as a senator and an MP, you should be required to be accountable to the people and to serve them with the utmost integrity, loyalty, and efficiency, and be accountable for certain forms of misconduct while in office. The MP or senator basically should lose their seat. Their seat would become vacant if what they do is so serious in nature as to render the holder of the office unfit to continue to hold that office, or it brings the office held by that person into disrepute. So what are the impeachable offences that would cause that to happen? There is 5. The first is corruption or the misappropriation of public funds or property. Number 2, the refusal to exercise or persistent neglect in the exercise of the duties or responsibilities of the office held by the senator or member of parliament. 3, the abuse of official authority. 4, deliberately misleading or intentionally abusing the privileges of Parliament. And number 5, egregious conduct or other misbehaviour that is unbefitting of the holder of the office of senator or a member of Parliament. So, like we just mentioned before, Marlene Malahoo Fort says it's difficult to provide for impeachment in a parliamentary system. Is it really? I mean, what are the consequences of not having it? I mean, it can be argued that it hinders the ability to improve the standard of living in Jamaica, and in this constitutional reform, this republic, Jamaica becoming a republic, maybe that's what people are looking for, right? An improvement in the standard of their living. There is an article that Professor Rosalie Hamilton wrote about 3 years ago. Sorry, I don't have the exact date, but it's called Our Jamaican Republic, the Bread and Butter Issues. And I'm just going to read you some quick excerpts from it, because basically what it's saying is, for many Jamaicans, this process really doesn't, what does it mean? It's not connected to their day-to-day struggles. And, they don't see a link between improving their standard of living and becoming a republic. And, there is a link to addressing the bread and butter economic issues of Jamaicans. It is the central objective to creating a republic. So what can be done to improve the standard of living? There are three key activities. This comes from a study that was done in 128 countries, right? What do you need to basically do to raise a country's standard of living? One is growing its capacity to innovate, right? To help make changes to something, to establish something, introducing something new, ideas, products, right? Innovation. Number two is building its capacity to produce, right? And export. And number three is upgrading its institutions, especially those related to law and business. So to transforming some key institutions, right? What institutions would those be? Education, health, innovation, and governance. So, among other things, the Constitution has two key features. It determines fundamental rights and freedoms, and it regulates the machinery of government, including its relationship with the people. These both directly affect standard of living. Constitutional reforms that regulate the machinery of government, including mechanism to hold the people's representatives accountable, also affect the standard of living of Jamaicans. I'm going to read that part again. The constitutional provisions that regulate the machinery of government, including mechanisms to hold the people's representatives accountable, also affect the standard of living of Jamaicans. Accountability in the management of public funds and effective oversight is critical. It's estimated that the cost of corruption to the Jamaican economy is more than 100 billion Jamaican dollars. With improved accountability, savings from a lower corruption cost can be redirected to innovative, income-earning activities that can improve the average income of Jamaicans on an annual basis. Constitutional and other legal or policy changes to improve accountability include impeachment provisions, as those outlined in the Constitutional Amendment Impeachment Bill of 2021 that we just talked about, recall legislation, a code of conduct for parliamentarians, and participatory budgeting. It's when people actively participate in decision-making through formally established mechanisms such as hearings and petitions that people can influence bread and butter decisions. So imagine if that corruption number is reduced by even half, right? And public officials are held accountable, made to justify actions or decisions, or to be held responsible. Imagine if savings from 50% of lower corruption costs could be redirected. What could you do with 50 billion Jamaican dollars? Well, the Spark program that the Prime Minister started, I think it was the end of last year, over 600 roads are slated to be fixed under this program, right? What's the cost of this program? $38 billion. Not even the whole 50. $38 billion. Imagine how many more roads this money could fix. Or you could pay each teacher, right? There's approximately 25,000 teachers in Jamaica. You could give each teacher a $2 million raise. That's about 13 grand, right? US. Would that help teacher retention? Would that stop Jamaican teachers leaving? I'm going to leave you with that thought, and I'm also going to leave you with a quote from the right excellent Marcus Garvey. We are no longer satisfied to have the vote and not to exercise it on our own behalf. As a reminder, if you're not registered to vote, March 31 is the deadline to register for the next voters list, which is scheduled to be published on May 31, 2025. If you're not registered to vote by that date, you're not going to be able to vote in the upcoming election that's due by September, or in the referendum, which could take place before November 30, which is the next voter registration date. I hope you're continuing to enjoy this journey, finding it educational and useful and ting. The topic of the 19th of March meeting actually is going to be the Senate provision, right? That's clauses 15 to 20. And then there's another meeting, the topic of the March 19 meeting, that was the Senate provision, right? The next meeting is actually due to be held March 26, which is tomorrow. The Joint Select Committee meetings are taking place weekly, so our travels on the rocky road to Jamaica becoming a republic will continue. The 1962 Order in Council has been in place for almost 63 years. The goal is for a constitution for the people of Jamaica, by the people of Jamaica, and of the people of Jamaica to last twice as long. How you feel? Still confident this journey is going to end with a truly independent and sovereign Jamaica land we love? Yeah, man. You can find this podcast on YouTube, Buzzsprout, Spotify, Podcast Index, Deezer, Podcast Addict, Apple, iHeartRadio, and Amazon Music. If you want to reason about anything, or if you can't find any of the material I was talking about, you can email me on atasteofja@outlook.com. So until the next time, I thank you for your support. Please subscribe, follow, and share it with family and friends. Like up the thing, man. Thank you for listening. One love, and yes, the word is love.